Hello, everyone. We'll get started in about 30 seconds. Hello, everyone, and welcome to the Environmental Law Institute's event, Advancing Tribal Sovereignty, Lessons from the Implementation of Tribal Consultation Laws in California. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. We're so excited to have you joining us this afternoon. We have a fantastic program planned for all of you today. I want to take a moment to thank our wonderful speakers for taking the time to join us as well. Today's event will be recorded and posted to the ELI website within a few business days of the program. So if you're unable to view the entire webinar, be sure to check out ELI's website later. Only 2 speakers will be using PowerPoint slides, but you can view their slides on the event webpage as well. We'll post the link to that in the chat. We'll be taking audience questions at the end of the program, so please feel free to put your questions in the Q&A box as soon as you think of them. There's no need to wait until the end of the webinar to submit your questions. You can submit them as soon as you think of them. While the chat will also be open for you to post any observations or chat amongst yourselves, we ask that you please post your questions in the Q&A box rather than the chat. Now I'll go ahead and introduce all of our speakers for today and then hand things over to our wonderful moderator. So our moderator is Greta Swanson. She's a visiting attorney at ELI. Greta has been closely involved with ELI initiatives in tribal consultation and co-management, marine conservation, and human rights in the environment. Her research and publications have addressed international protections of sharks, community fisheries management in the Mesoamerican reef, human rights in the environmental rule of law, and government-to-government consultation and co-management with Alaska Natives. Prior to her work at ELI, she was a law fellow with Oceana. Greta holds a BA from the University of Washington in anthropology and a JD from the New York University School of Law. Additionally, our speakers today, I'll go ahead and introduce each of them. First up, we have Mary Lopez Kiefer. Mary was appointed Director of the Office of Native American Affairs in the Office of the Attorney General, California Department of Justice by Attorneys General Rob Bonta and Javier Becerra. As the Attorney General's legal and policy advisor on tribal affairs, she works closely with California's Native American tribes to facilitate engagement and coordination with the state on mutual concerns. She also serves as a liaison between the department's legal and law enforcement divisions and tribal governments. Mary's work spans public safety, child welfare, civil rights, land use, environmental justice, health equity, and tribal state economic issues. Before joining the Attorney General's office, she spent 15 years as chief legal counsel for the San Luis Rey Bands of Mission Indians, where she worked to protect Luiseno culture, sacred sites, and tribal rights. She also served as an assistant district attorney in San Francisco, specializing in domestic violence prosecutions. Mary holds a JD from Boston College Law School and a BA in Law and Society from the University of California, Santa Barbara. Our second speaker today is Sean Scruggs. Sean is the Tribal Historic Preservation Officer for the Fort Independence Indian Reservation in California and serves on the Tribal Advisory Committee at San Francisco State University. With 6 years of experience in consultation and relationship building, Sean works tirelessly to repatriate ancestors, protect his ancestral homelands, address gaps in the Section 106 consultation process, and advocate for cultural education among leaders at all levels. Sean earned a master's in organizational management in 1999 and retired from the U.S. Air Force in 2009, where he served as an aircraft structural maintenance master technician and officer. Since 2018, Sean has contributed to significant projects, including co-authoring a national register nomination for Patsiata in California, serving on a writers group that crafted Appendix K of the 2018 Legislative Environmental Impact Study, and recently speaking at the 58th Annual Society for California Archaeologists President's plenary session. And then last but not least, we have Stephen Lazar. Stephen is a senior planner in the Humboldt County Planning and Building Department. Stephen has over 20 years of experience as a public land use planner. After earning an MS in natural resource planning and interpretation with a minor in environmental ethics from Humboldt State University in 2003, he joined the County of Humboldt as a planner in 2005. Stephen played a key role in developing California's first commercial medical marijuana land use ordinance in 2015 and served as the primary author of the 2018 amendments to the regulations. In 2011, Stephen began coordinating meetings with local tribes and THPOs in Humboldt County to collaborate on the development of resources and referral protocols. He attributes relationships cultivated during the time to be pivotal to safeguarding tribal cultural resources during policy development and implementation of the local cannabis regulations. Stephen also serves as planning commissioner for the city of Eureka. So thank you so much to all of our speakers for joining us and to Greta for moderating. I'll hand things over to you, Greta. Thank you all.
Thank you, Madison. Good morning, good afternoon, everybody. Since Executive Order 13171 was issued, 13175 was issued in 2000, the federal government, along with tribes, has undertaken many policy initiatives to develop and improve government-to-government consultation. At the same time, states and localities are making many development decisions that impact traditional lands of tribes and interests. One challenge at the state and local level is that there's not necessarily the trust relationship that exists at the federal level. However, some states are promoting a government-to-government relationship with tribes and developing tribal consultation laws and practices, which is what this project is about. I wanted to thank our partners. Do we have a slide up? I want to thank our partners, the National Association of Tribal Historic Preservation Officers, National Native American Rights Foundation Fund, the National Indian Law Library, Dr. Jamie Donatuto, who worked with the late Swinomish elder Larry Campbell, and the Dry Creek Rancheria Band of Como Indians. Also, thanks to our California-based steering committee, the ELI team, and many others who have been helpful. We received support for this project from the RWJF and Henry Luce Foundation. I'm first going to briefly discuss the laws for those who aren't familiar with them, then some of our project results. Next slide, please. California is unique in the diversity of tribes that and cultures in California. There's a long history of displacement, forced labor, and genocide, which was actually state sanctioned. But in the 2000s, Native Americans, I'm backing up a bit. In the 1850s, Native Americans signed treaties with the US federal government, which would have set aside a significant amount of the land of California for the tribes. However, the Senate failed to ratify them, leaving tribes with, at this point, probably less than about 3% of California land. But after years of tribal advocacy, California started to make changes. And I'm going to talk about two laws that were passed 2004, passed SB 18, and 2014 SB 18. AB 52. At the same time, the governor issued executive orders mandating that state agencies develop tribal consultation policies, and a later one setting forth a Truth and Healing Commission. And there are other laws that have also supported tribal consultation in California. Next slide. Both of the laws, SB 18 and AB 52, use the same definition of consultation, emphasizing a meaningful process that is timely, carefully considers views, recognizes cultural values, reaches agreement if feasible, is respectful of sovereignty, and protects confidentiality. Next slide, please. Both laws also require consultation with both the non-federally recognized and federally recognized California Native American tribes. These tribes are identified and listed by the Native American Heritage Commission, an agency in California. Both laws also seek to protect confidentiality, and as AB 52 specifically prohibits public disclosure of tribal information without their consent. They are different in which agencies consult and on what topics. In the case of SB 18, it applies to local governments that are consulting on plans, plan amendments, and specific plans. AB 52 applies to lead agencies that are leading environmental reviews under the California Environmental Quality Act. As for topics of consultation, both deal with tribal cultural things in slightly different ways. Under SB 18, the subject of consultation has been referred to as traditional tribal cultural places, which includes religious sites and eligible listed sites on the California Register of Historic Places. In the case of AB 52, there's a new term, tribal cultural resources, which must be also eligible and listed or listed on the California Register. Then agencies determine their significance, and for that determination, agencies must consider the tribe's information about the cultural resource. Next slide, please. Moving on to the procedures, they do have slightly different procedures. Before a local government is adopting a plan, it must conduct consultation or offer the consultation to tribes. First, it contacts the Native American Heritage Commission for a list of affiliated tribes, then sends notice to those tribes. Tribes have 90 days to respond, decide if they want to consult. Consultation needs to be concluded before the plan or amendment is adopted. Under AB 52, there's a strict timeline, 14 days. Within 14 days of deciding to undertake an action or determining that a project application is complete, agencies are to contact tribes. Tribes only have 30 days to respond in writing, and then the agency needs to take prompt action to start consultation. Consultation is concluded before the environmental document is finalized. AB 52 defines the conclusion of consultation. The conclusion is either when there's an agreement on mitigation or avoidance measures, or one party decides after reasonable effort and a good faith that they cannot reach agreement. That part is not defined. SB 18 called for the development of tribal consultation guidelines in order to develop better practices, set forth the best practices for consultation. That was done with the input of California tribes. Next slide, please. Moving on to our project, we undertook to evaluate the effectiveness of state and local tribal consultation under two consultation laws to achieve statutory goals and related tribal sovereignty and their goals. Some of these goals include protecting tribal cultural resources and places and the confidentiality of tribal information. We took several approaches. We evaluated the laws from a legal and historic perspective, looked at some environmental impact reports, conducted interviews with tribal, state, and local officials, legal experts, and consultants, conducted a survey of tribes, researched case studies of consultation, and created a set of Indigenous health indicators for a partner tribe. On the basis of our work, we developed recommendations for implementation of consultation. We sent a survey to 141 federally recognized and non-federally recognized California Native American tribes, received 23 responses, and conducted follow-up interviews with 6. Although we cannot draw statistical conclusions from these responses, we did look at the responses as providing trends and examples that were helpful. Next slide, please. As far as survey results, most tribes had similar goals for consultation under the laws. They sought to preserve and avoid disturbance of resources, document the resources, engage in cultural management, protect cultural heritage, and use creative mitigation of impacts. There were many other goals that were listed as well. As far as general trends, on the positive side, the vast majority of people who responded said that there were increased opportunities for consultation. The laws have set a framework for tribes to be at the table. A substantial minority, 1/4 to 1/3, depending upon the question, saw substantive improvements in effectiveness, greater protection of cultural resources, more ability to make changes early in the project to mitigate impacts, and improved relationships with lead agencies. A very small minority, in response to a question, reported increased opportunities for healing. For the majority of tribes who responded, there were still limitations. And as between federally recognized and non-federally recognized tribes, non-federally recognized tribes experienced even more difficulty carrying out effective consultation. And I'll touch on that with some of the issues. Next slide, please. touching on some of the issues that we addressed in this survey. This group of issues are some of the things that need to be in place before consultation takes place and ongoing throughout consultation. Confidentiality can be a catch-22. On the one hand, tribes need to share information in order to protect them. On the other hand, they may be distrustful of agencies as far as keeping the information confidential based on experiences that have been reported. The laws also do not, although the laws prohibit disclosure, they do not set out penalties for disclosure. Good relationships are fundamental. They facilitate consultation. They can lead to regular communication between tribes and agencies about upcoming projects and plans. They may provide a greater role for tribes in the form of membership on task forces, decision-making groups, and tribal advisory committees. About a third of respondents and half of the non-federally recognized tribes reported that the laws had improved relationships with agencies. Others stressed the wide variation in relationships depending upon the particular government agency. As far as resources, consultation is an unfunded mandate imposed on tribes. The majority of tribal respondents and 2/3 of non-federally recognized tribes identified limited resources as constraining effective participation in consultation. For non-federally recognized tribes, there are no funds for a tribal historic preservation officer. Education issues for agencies addresses whether the staff has a good understanding of the laws and requirements and potential, as well as an understanding of the tribes and the tribal goals of those tribes with whom they are consulting. Most tribes did not indicate a need for further education, although some did, but about half indicated a need for agencies to have additional information about training on the laws, as well as on tribal issues. Next slide, please. Moving on to procedures and substantive requirements in the laws. Ensuring the engagement of tribes in consultation requires early notification. This gives our tribes the opportunity to provide their perspective and information before key decisions are made. About a third said that they were learning about projects early enough to make impacts. On timeline, 2/3 of the respondents indicated that the tribes do not give them sufficient time to consult to the degree that they are seeking. The question of weight to be given to tribal information relates to what kind of impact does this information have on outcomes? Providing sufficient deference to tribes' information is necessary to protect the resources and places and for tribes to achieve their objectives. About 2/3 of federally recognized tribes and over 80% of non-federally recognized tribes reported that tribal expertise is not given sufficient weight in the decisions. A majority of federally recognized tribes and all of the non-federally recognized tribes reported that the reports of archaeologists or cultural resource management firms are the primary determinant of the final findings and recommendations on cultural resources. Several noted the importance of engaging tribes in cultural surveys, initial cultural surveys. Creative mitigation is another way in which tribes can have an impact on final decisions. They would like these to be considered equally. When critical decisions have already been made about the project, mitigation decision options often become limited. As far as accountability measures are not built into the laws, although I know Mary's going to talk a little bit about that later. They don't provide for implementation and management of a project, although these can be mitigation measures. Cultural management of resources is a goal for the vast majority of tribes who responded. And about 30% of tribes disagree that decisions made during consultation were implemented. Next slide, please. I'm going to finish with just a plug for another part of the project, which is a database of tribal consultation policies and laws across the nation. This is a free resource that ELI has developed with partners. Includes policies and laws and related documents of tribes, state agencies, the federal government, and some localities. And we are in the process of adding a phase 2 that will include consultation resources and such as best practices and training webinars. And we'll be posting the results of this project on that website as well. Next slide. Thank you so much for your time. And I'm going to, there's the QR code for the website. I'd like to turn it over to Sean Scruggs, HIPPO for the Fort Independence Indian Reservation.
Manahu, Shan na ni nani, Nu Chucky Shave Weta. Good morning, everybody. I am Sean Scruggs. I am Chucky Shave Weta, Oak Creek, from Fort Independence Indian Reservation, California. Our reservation was established on 28 October 1915 by Executive Order 2264, signed by Woodrow Wilson. Today, I'm going to give a disclaimer and a lead-in to my concerns with consultation and speaking to the earlier effort of what I do with education when people approach me and want to know about our tribe and our place in our valley. Our valley is Payahanadu, the land of flowing water. My disclaimer today, I do not speak on behalf of any other TIPO, tribal chair, vice chair, or elder. Each tribe is distinct. Each tribe has their own story. Each tribe has their own experience and place in history. It is extremely important in consultation that agencies, state, local, federal agencies, and project developers understand that they cannot just add a blanket application of the collective experience of First Nations, First People. Today is what I'm going to share is my experience as a TIPO since 2018 with my tribe. I'm going to ask you to think about an analogy as I go on with my introduction here. I'm willing to bet that almost everyone on this phone call, on this webinar today, either has lived in a house or lives in a home. If you do you lock your doors at night? And if you do, why do you do that? I'm going to go on to my introduction and then come back to that question. Our people in our homes and our valleys pre-contact, and I don't acknowledge the terms prehistoric or hunter-gatherer. My tribe has a history. We've been in our valley since the beginning of time. We had no locks on our doors. We have, in my view, personally, I view my valley, my entire valley, which is in Eastern California, as a church, a place of worship in that sense. Also a supermarket, a place where we had food, a place where we lived since the beginning of time. We had no way to lock it and protect it. At contact, the cavalry, along with settlers, came in and began to destroy that place. Since the 1800s and before, our people have been murdered, forced from the land. We've experienced genocide, assimilation, theft of our cultural resources, and collections have served to present a concept of erasure. Currently, since 2018, I've been in easily 500 to 600 consultation meetings and received, at this point, about 10 to 15, sometimes 20 consultations in a month. As our tribe, we're extremely small. We have a small tribal government, and our capacity is extremely limited when it comes to answering and being able to spend time on consultation efforts. I'm quickly going to go back to the question I asked earlier about why would you have locks on your doors? Why would you protect? And that's exactly it. People have a need and they want to protect what they believe, how they live, and their places, either their homes or their yards, their ranches, their cities even. And it's this need to protect that we still, as TIPOs, as elders, as tribal leaders, as sovereign nations, we still have a need to protect our ancestral homelands, our ways of life, and our beliefs. We are not gone. We are still on the lands. And when people want to consult, now the other part of this is people are not coming to consult how to make our lives better. They still want to consult on how to mitigate or minimize the damage that's going to be done to still the places that are ancestral homelands, our places of worship. Many times I receive reports that state that no cultural resources were found when consultation happens. And we're at the tail end of it still, stating that most of the work has already been done. For me, just to frame it, personally, consultation is as soon as an idea is born, an agency thinks of a project or an idea and they're not sure what to do, the next step is to consult your local tribes and affiliated tribes to get their ideas, their understanding of how this is going to impact the environment, the insects, the lands. And a lot of people at times, it's not just the physical land itself. Ground disturbance is likely to happen, but it also affects visual landscapes. It affects the water, the entire environment. Those are important considerations. As far as capacity, I'm not an environmental scientist, but my traditional ecological knowledge, my upbringing, my beliefs tell me pretty much everything I need to know that everything is going to have an impact. It's a privilege to be working with ELI on this project. It's a privilege today to speak to you. I say everything today, respectfully, because it's an opportunity to build relationships, to help the audience who's viewing this today to understand the challenges that we have as tribal people and why consultation is so important. And there may even be reasons why we don't consult back, to include protection of cultural sites, sacred sites. And we're looking for ways to share that information with the people that need it, but it's a very delicate process going forward. Thank you for allowing me to introduce myself. I look forward to answering questions and sharing my experience today. Thank you.
Move on to Steve.
Okay, great. If someone could bring up the slideshow. And then give me control of the slides. Okay, thank you. So yes, my name's Steve Lazar. I work for Humboldt County Planning and Building Department, and I've worked there for almost 20 years. And I've worked as a land use planner in California for over 20 years. I'm going to be sharing some of my experience in the last 10 to 15 years and dealing with our department negotiating the important goal of tribal consultation in all its forms. And I'm going to speak about some of the experiences that I was able to have firsthand and how they have reflect the sort of evolution that's underway. So this next slide shows the county that where I work, the unincorporated areas of the county are what I work with. And within this area of California near the northwest corner, there are no less than 8 different federally recognized tribes at this moment, and really arguably additional federally recognized tribes that lie on county boundaries with other neighboring counties. And the other tribes that are not recognized, that I can name at least 3 at this moment. And in the course of negotiating, like I said earlier, this evolution, it's been about improving relationships with all of these entities, not just the federally recognized tribes, but all the tribes that we have in our county at this moment. So some local milestones I wanted to walk through and kind of take some time on each one involve kind of what precipitated my role and involvement in this. In 2011, I was working on a discretionary permit in the coastal zone where the project was approved, and after the approval had occurred within a week or two, I was contacted by the Tribal Historic Preservation Officer for the Blue Lake Rancheria, a woman named Janet Eisnes, who recently retired, telling me that why were they not consulted on the project, as they own property across the street and this is within their ancestral territory. And in my naivete, I just saw the name Blue Lake and thought, well, this wasn't in the city of Blue Lake. Why would this be, something that we needed to speak with you about? Well, there begins kind of showcasing that kind of ignorance and the importance of really refining and improving the understanding and relationships with the tribes. It was a difficult situation. We had to negotiate an approval that the site was sensitive. The tribe had purchased the property across the street because it was also very sensitive, had cultural resources on it. There was an earlier project that involved subdivision. That was why the tribe bought the property across the street. Another planner in our department had been party to the discussions with the tribe, but because him and I were not, it was a left hand, right hand situation. We didn't know that that knowledge wasn't shared across our organization. So in the wake of all of that, we were able to negotiate that successfully. The project ultimately was built out. Local students from the university worked to do field work in tandem with the TIPO for the tribe. And thankfully, we were able to kind of find a spot for the development project to occur. But after that, we started talking about like what went wrong and why, and how we can avoid this continuing to occur. And so that's what led to establishing protocols that were sort of in the spirit of AB 52, but long before, or at least years before AB 52 had come online. Senate Bill 18 had been in place for almost a decade at that point. However, because Senate Bill 18 really only deals with changes to land use plans, it wasn't something that our organization dealt with very regularly. Land use plan, like general plan and specific plans, those types of changes usually happen on a multi-decade basis, so every 20 years potentially. So it's not the kind of thing that's a frequent flyer item. The protocols that we established in the wake of that issue with that project were things such as figuring out which tribes we need to engage with, even ones that are not federally recognized, when we should engage with them versus when they don't need to be contacted, which involved developing mapping in consultation with the tribes. It also involved coming up with protocols for how we would contact them, knowing that, you know, in the case of the project that I worked on, the TIPO had been contacted for one of the Wiyot ancestral tribes, the Wiyot tribe, but they were on maternity leave. And because they didn't respond within the timeframes of our referral protocol, we assumed their response was, you know, no big deal. So in the wake of that, we made it clear that it was important for us to circle back and make sure that we actually get a response from the tribe, positive or negative, not assume that non-response is an acceptable outcome. So the mapping that we developed, I'll show not the actual maps, but kind of what it looks like as far as the number of tribes that we were able to get mapping from. That process was tedious and it took several years. It involved us developing maps on behalf of the tribes, signing agreements to keep the mapping that was provided to us confidential, which we continue to do to this day. It's for internal use only. It also involved, I can tell the story of one of the tribes that's non-federally recognized is a Sinungwe. They have members of the Hoopa Valley tribe, but other members of non-recognized tribes that are still seeking federal recognition and have a definite area, but they didn't have any maps they could provide to us. I worked with our GIS technician. We printed out a large format map with roads and the rivers and things, and provided it to I had to send it to a PO box in Sallier. It took 2 years before one day I was called to the front counter and there was an elderly fellow there who came up to me and said, "Hey, I have something for you." He rolled out the map. There it was. They had drawn the boundaries of where they believed their ancestral territory was, which we then used to actually create a GIS layer from. So it was things like that that became, we had to be proactive as an agency. When 2014, 2015 happens and AB 52 comes on the scene, incorporating more requirements for a broader assortment of scenarios by local agencies, we already felt like we were doing above and beyond what the law called for. So it really didn't change our approach, which was really nice to actually have. In developing our local cannabis regulations that came in 2015, that was a very compressed process. The state had passed laws at the end of the legislative session, September 11th, 2015. It gave local agencies until March 1st of 2016 to develop their own regulations. Otherwise, they would forfeit all local control over cannabis to the state, which would have been a terrible outcome for our county and others. It meant that we had to run through a process in less than 5 months, 4.5 months, start to finish from September 15th to meet the March 1st deadline, which meant that when we started the process where we had to prepare an initial study and mitigate a negative declaration pursuant to CEQA, there was no way to meet AB 52 prescribed timeframes and still complete the ordinance in time for adoption, which meant that we banked on the progress we made with those TIPOs to go through an intimate conversation where we arrived at some policy choices that were presented and embedded into the ordinance and helped address tribal concerns. Some of those processes that I would offer today were things like making sure that tribes define what constitutes a tribal cultural resource, not the agency, and it through an action of a tribal council or an equivalent body. That was something that gave the tribes confidence in our ordinance. It came with a tribal cultural resources and are entitled to 600-foot buffers, which was something that we built into the regulations. The buffers can be waived or reduced, but only from the tribe, not from the local agency. Additional things that were included were a requirement to consult and the tribe having the ability to request a cultural resources survey and the agency not having any discretion about that. Those are the types of things that we were able to kind of bake into the regulations to give some confidence. And thankfully, we were able to get our regulations online. And as a consequence, we had many, many surveys done in the wake of those regulations, far more than I expected. But in the end, I think it really helped us and the tribes negotiate that. Another important milestone is after our regulations were adopted, the Yurok tribe created a ceremonial district through tribal council action. It had a profound impact on cannabis operators in that area, ultimately eliminating the ability for many operators to seek a permit at the local level. Thankfully, we had rules in place in our cannabis regulations that allowed sites to be restored and get credit for remediation and restoration. And that actually led to the tribe acquiring property from cannabis operators and buying the property or receiving, and then the operators actually got credit to bank to use at a new location in a more appropriate setting. So we had a kind of almost like pollution credits, transfers of development rights. So things like that we innovated in our cannabis regulations ultimately helped us negotiate a difficult situation where the tribes had very much at stake and we had very many successful outcomes as a result of it. But it wasn't something that was easy. It required people to negotiate that. And then just some additional refinements that I think are important to make note of is when we adopted amendments to our regulations in 2018, we included a concept of a tribal ceremonial site, not just a tribal cultural resources, and afforded that a larger setback of upwards of 1,000 feet. And that created additional comfort for the tribe so that there was more deference to those types of situations. So moving on from that, let's see here. I want to talk about some of the gaps that currently exist in the regulatory framework that we're dealing with under SB 18 and AB 52. First and foremost is when tribes are engaged. There are prescriptions in both laws, and they differ. In the case of, I think SB 18, it's a 45-day within, and in the case of AB 52, it's a little shorter. But the important part that has become quite clear to me is engagement really needs to happen as early as possible. That principle is not unique to tribal situations, but it's particularly incumbent when you're dealing with the difficulties of modifying a project late in the game. You just really lose the ability to come up with effective mitigation at that point. So in our cannabis regulations on the second iteration, we have a notification to the tribe at the application outset. So the project comes in over the counter, whether it's a complete application or not, we give the tribe knowledge of the application being received. That's as early as we can do. But it can even be improved upon because oftentimes projects don't just magically land over the counter. There's conversations between counter staff well in advance of that. And having that education within an organization and institution helps so that we can kind of catch that at an early stage before somebody's hired their archaeological professional, before somebody's finalized their project design. And that's really how you can improve upon the rules that are already in place. Next, I think it's important to recognize that the laws are different with respect to federal and non-federal tribes. AB 52 is more comprehensive, SB 18 less. In the case of the approach that we took back in 2011, we didn't distinguish between either situation. We wanted to give every tribe that was interested an opportunity to be consulted, to be engaged, to be referred. I think it's also, it needs to be acknowledged that under AB 52, it really doesn't, a tribe can, there's an agree to disagree provision. You can go work the process, but at the end of the day, the lead agency can say, we're sorry, we couldn't work something out. We need to move forward. Well, that's not the approach that we took with our cannabis regulations. We gave the tribe the deference when it came to deciding what was appropriate. That's not going to be popular in every jurisdiction, but that is the type of direction that needs to occur for there to be greater comfort and trust built between the relationships between agencies and tribes. Compensation is an issue. It's not, there's no provisions or requirements within either law. It's something that our tribes have come up with fees. We've passed those fees on to project applicants. Part of what you do as a lead agency is you set the tone for what is occurring, and staff at the line level are how you normalize these types of things and keep that kind of friction from coming that can naturally occur when someone goes, what do you mean I got to pay for the person who's going to decide whether or not my project gets approved? It's really important, and it's part of that relationship. And then lastly, as it stands right now, if a building permit is the only action in play, there's really no protection under SB 18 or AB 52. And building permits can have profound impacts on cultural resources. So just understand that these are these situations. In our general plan, we have policies that apply to ministerial projects. So that's where we've gone above and beyond what these laws prescribe. Moving on, I wanted to say, with regard to our mapping effort, the mapping is confidential, but to give you an idea of what sort of occurred, this is sort of a cross section of the center of our county. You can see on the right side here, these are layers that we have on our GIS. Each one of these came from one by one engagement with tribes to develop the spatial information that we use to know when and where to consult. And just, looking at that list real quick here, these are tribes that we've managed to get that information from and done it, like I said, on a case-by-case basis. And then you can see here where the Yurok tribe provided a polygon layer so we can quickly notify applicants that are within an area of sensitivity. Not every tribe is going to be comfortable with that. So it's important for agencies to kind of recognize there's confidentiality at the heart of this. But we, I believe, really do benefit by the planners knowing where these areas are. It gives us the ability to intercept these things early in the process. And then last, I'm going to end with some best practices. Some of this I've already spoke to. I think it's important to recognize that these laws are a floor, not a ceiling in that regard. Early consultation is the best, making sure that counter staff understand and are able to coach applicants as early as possible and start normalizing and setting up that anticipation of that part of the process. Making sure the agents and applicants understand what may be required of them and encouraging them to, for instance, before a project's even submitted over the counter, maybe a site visit with the TIPO would be a good idea. And maybe you're going to have to pay for it, but it might save you a ton of time in the long run. That's the kind of stuff that isn't baked into these laws, but will make a huge difference for applicants and tribes in trying to get these things resolved in a manner that's satisfactory to all parties. And for that reason, agency staff need to have that training and understanding and be sensitive and have those spidey senses to know, wait a minute, this is, I learned a very, kind of important lesson, when we created the cannabis regulations and gave tribes the ability to require cultural resources surveys, I thought we'd have maybe 5% of our projects, have to have a cultural resources survey. Boy, was I wrong. I mean, we're talking 500 to 1,000. We had 3,500 cannabis applications within a matter of a year. And most 80% probably all had cultural resources surveys. Well, knowing a little more now, a place where you grow cannabis is somewhere that's going to be the south side of a slope. It's going to be close to a water source. And it's probably going to be the flattest place around. Well, that means it's probably a great place to camp, and it was a great place to camp 1,000 years ago and 10,000 years ago. So of course there's going to be an understanding when staff have a little more insight into those things and can better, kind of tip off an applicant to like, hey, let's not expect that this is going to be a slam dunk. And then, I think an important component that's not baked into the laws is making sure the TIPO or the tribe is given an opportunity to interact with the cultural resources professional if a survey is being required, so that the survey is correctly targeted, the backstory and background is on point. Otherwise, it just creates more work for everybody, and it really kind of leads to a bad work product. And then lastly, closing the loops with the tribes, as I mentioned earlier, is important. Not just accepting no answer as an answer, and making sure that there's that understanding. And then I would say, in our case, we were able to build trust with our local tribes because we did it when we weren't required to. We did it in the spirit of, we need your help. We can't We can't be arrogant about what we know and what we don't know. And the only way we're going to be able to do that is by developing that capacity and relationship. And there's more work to be done for all of us. But I think where we're at this point, we've got a good start. And as long as we continue to evolve, we'll be in a good place. So that's the end of my presentation. I'm open to answer questions later. And I think I went a little long, but I appreciate your patience.
Thank you. Mary is up next.
I'd want to go after Steve. Miriam, notang Mary Lopez Kiefer, Yoa, notang Bayam Kuichum, Ki Ketchawanish. Hello, everybody. My name is Mary Lopez Kiefer. I am a member of the San Luis Rey Band of Mission Indians, a California Native American tribe that is traditionally and culturally affiliated in Southern California. So if anybody knows Camp Pendleton or Northern San Diego County, that is where my ancestors are from. We are known as the Payam-Gawisham, meaning people of the West. We are known today as Luceños. As you could hear from the name of my tribe, we are associated with the San Luis Rey Mission in Oceanside, California. I come to you today as the Director of the Office of Native American Affairs at the California Department of Justice. I serve as the Legal and Policy Advisor on Tribal Affairs to Attorney General Rob Bonta. And one of the areas that Attorney General Bonta is focusing his attention on is the enforcement of Assembly Bill 52. That is the change into CEQA, the California Environmental Quality Act. I want to first, before I even begin, applaud Steve's and the County of Humboldt's efforts in developing such a robust and fruitful consultation policy with their 8 tribes. Because I know we have people joining us from outside the state, I just wanted to give a quick snapshot of what how many tribes we have here in California. Greta announced in the beginning that for their survey, they had done some outreach to about 141 tribes, both federally recognized and non-federally recognized. But just to put it in perspective, there's about 167 California Native American tribes, 109 federally recognized tribes, meaning that they have a government-to-government relationship with the federal government, and then you also within a trust relationship, and then you also about 65 tribes who do not have a government-to-government relationship with the federal government, but are on the Native American Heritage Contact List as a tribe. So when we use the phrase California Native American tribe in California statutes, it is to reference both political status tribes. Another little tidbit is that SB 18 impacted cities and counties. California is a very large state. We have about 483 municipalities, meaning cities, and 58 counties. The map of California includes about 105 reservations and rancherias, and those are located within 34 of our 58 counties. And California is home to the most diverse population of American Indian Alaska Natives. So our maps are just through the roof, and where Humboldt County, it's almost at the top, they're right next to Del Norte, has 8 tribes that it serves. All the way down to the south, San Diego County, it serves 17 federally recognized tribes and 2 non-federally recognized tribes. So when you're looking at things about like SB 18, you kind of look to these counties and say, how do you do this, right? Because these were brand new laws for the state of California. SB 18 was passed in 2004, but it didn't go into effect until 2005. because they knew they had to give time for the guidelines to be developed and for counties to learn how to interact with tribes and tribes to learn how to interact with counties. It was very tense relationships for most tribes and most counties. If you don't know anything about California Indian history, I recommend that you learn it. The state had done atrocities to its California Native population and interfered with treaty making and also had passed many laws that were incredibly detrimental to our California Native Americans, to the tribes, and to its citizens. So starting at the local level was quite the challenge. So I mentioned that started in 2005. It was followed up with Executive Order B-1011 from Governor Jerry Brown, and that required consultations from executive agencies with all California Native American tribes so that they could provide input on policies, regulations that might impact them. Then we had Assembly Bill 52, which is one of the main points of our discussion today, which changed CEQA, our California Environmental Quality Act. It's important to know that before this time, if a project was coming into your territory, your ancestral territory, you were a member of the public, meaning the tribe would have to provide their comments as a member of the public. There was no protection for their information, and they had to literally put everything out there to save an area. One of the things you need to understand is if a tribe does that, then they are putting that area in danger, because pot hunting is real, desecration of sites is real. And so a tribe had to be in that situation. Do I say something? Do I not say something to protect the site? So tribes and agencies and county governments were learning how to engage with one another, develop mutual respect, figure out how to communicate with one another, understand each other's capacity levels. A lot of members of non-federally recognized tribes who were entrusted to protect cultural sites, this was a second job. They would have their day job, and then they would try to protect sites. So engaging with those local agencies, you learn about each other. Assembly Bill 52 created tribal cultural resources. That terminology had never been used before in state law, and also made a very important statement. It said any substantive impact to a tribal cultural resource is a significant impact to the environment, and therefore more review would be necessary to determine if that action should be avoided or if it should be mitigated. And so AB 52 was very, very important in the area of protection of cultural resources. Now, the role of the Attorney General, that is why I'm here. So I mentioned CEQA a couple of times now. It's over 40 years old, and it's one of the state's most important environmental laws. The act established a state policy of sustainability to create and maintain conditions under which man and nature can exist in productive harmony to fulfill the social and economic requirements of present and future generations. It requires state and local agencies to evaluate the significant environmental impacts of proposed projects and adopt feasible mitigation measures to reduce or eliminate those impacts. And I just shared AB 52 changed it so that if there was a substantial impact to a tribal cultural resource, then that would be considered a significant effect on the environment. The Attorney General, in his independent capacity, has a very special role in overseeing and enforcing CEQA. The Attorney General focuses on how to address those impacts that affect our most vulnerable residents and our futures, right? And that can look like the Attorney General providing comments to environmental impact reports, as well as filing amicus briefs or participating in settlement discussions. So AB 52 was passed in 2014, but like SB 18, it was given time for its effective date. So it didn't actually come into effect until July of 2015. And in that time, there were many things that had to happen, including the Native American Heritage Commission had to determine which lead agencies would need to contact tribes and which tribes would need to contact lead agencies. So there was a whole mapping responsibility they had. And then the tribes had to then, digest this information, which could have been over 500 lead agencies, decide who they were going to provide notice to so that they could be then be given AB 52 notice so that consultations could occur. I mentioned this because it's now 2024 and there's not a lot of case law yet in helping tribes or lead agencies in really figuring things out. There's a lot of guidance materials out there on Assembly Bill 52, as well as SB 18, the Office of Policy and Research from the governor's office. They have guidelines. The Native American Heritage Commission has guidelines, as well as templates on tribes who want to provide such notice to lead agencies. Excellent templates. And then why the Attorney General is now becoming involved. What's happened is there are two different types of cases coming up through our court system here in California, and they are considered cases of first impression for Assembly Bill 52. The Attorney General has filed amicus briefs in both matters, and these amicus briefs are really focusing on what meaningful consultation looks like, and also what agencies need to be considering when working with the tribe and that tribe is providing expertise in their area and their cultural resources. A lot of what Steve had described about early consultation and working together until you have this understanding that's deferential to the tribes, that's a gold standard. Unfortunately, that's not happening throughout the state. And so that is why the Attorney General is starting to become more involved in how agencies are assessing, evaluating, and mitigating for impacts to cultural resources. Again, really looking at that term of meaningful consultation and how it requires more than a cursory approach. And then also how agencies are receiving from tribes and how they're considering tribal expertise, because the statute does require that they do consider it and how it impacts the cultural resources. So that is one of the areas that I wanted to share today about how the Attorney General's office is becoming more involved and keeping providing those comments and amici to show what is necessary in developing these relationships and how it can be beneficial for future generations by our respecting tribal sovereignty, but also respecting that tribal traditional knowledge that is, incredibly important, especially given the role the state played in the genocide against its First People. Happy to answer questions.
Thank you so much, and thank you all. You have amazing presentations and ideas. about consultation. I wanted to get to a couple of questions. I'm going to start out with a question that I have, and I know you have touched on this. And Steve, you had some very specific suggestions for the timeline, but do the others, or did you want to add to your thoughts on notifying tribes earlier in the pipeline? How would you define the point at which tribes should be involved, become informed? Is that something that can be defined? And related to that, how should developers be contacting tribes, or should they be? And I'll just open it up to any of the panelists.
Yeah, I'll go in real quick. Just a couple of things here. EJ Jones quickly asked about sources. So it's incredibly difficult to provide sources because you have to look at the authenticity and who's writing the information and where that's coming from. Regarding who's going to contact the tribes, it's very difficult because most of my information comes to me some is through private developers, and some of it's through Bureau of Land Management or a lot of the agencies that are already existing in my valley. One of the things that becomes incredibly difficult with it in that notification is there's a presumption that our tribes are absent from the land. There's a perception that our tribes only live on the designated boundaries. And when we try to describe culturally how big our area is, our use of land since the beginning of time, I think there's also an idea that, oh, this is 140 miles from your reservation. We're just checking with you to see if it's okay, make sure we develop this area. But for me, as a TIPO, as a person who does this work, it's very necessary for me personally to see the site itself, to walk the land, to visit the site. I cannot legitimately answer and respond to consultation requests unless I know an ethnographic history. So a lot of times in TIPO work, we call for, in addition to a cultural resource management firm or someone going to actually see the land itself, the site. This is the need for early consultation, is that if we visit the site immediately and know the area, it's more possible for us to know the stories, how the land was impacted after contact, because our way of life changed. And this drives the necessity for people to come to us immediately and understand that they're probably going to get a request for a lot of extra consultation. And just real quick, how do I prioritize this? It's very difficult. I try to respond to everybody almost immediately when they're coming to consultation because I need to know where they're at in the process. One of the ones I just looked at really was a lithium mine that's being proposed. It's been 5 years that they've been working on it, and I literally had 48 hours. I was brought in so late, and it's not really the fault of the people who were in charge of the project. It was so late that I turned the product around in about 48 hours to deliver a 5-page response. And to also follow up to one of the questions in that quickly was Anita Parlow, can the tribe say no? They can. Actually, in the environmental assessments, we can say no, and we can ask for informed prior consent. We're also now working and exploring ways to see what the mitigation looks like when we say no, because of the lack of continuing consultation. These are new areas. I yield the floor to anybody else quickly, and I look forward to responding to some more questions. Thank you.
I guess I'll just add to what I was saying earlier, just that, I think that the agencies have a role to play in ensuring consultation or something approaching it occurs as early as possible, which means that there really has to be that cross-training within an organization so that the people that are in the positions to be interacting with public, with applicants, with agents, with consultants can direct that to the appropriate party. And as someone working in an agency, I always feel more comfortable being the liaison between the applicant, agent, and the tribe, and not pushing a developer to the tribe. It makes for a more we can be more frank with the TIPO. We have a relationship preferably, and then we can begin that crosswalk to the applicant or agent if that's. But I always I like to approach it that way.
So early and often is the key. When you have information, you should share it with the tribe. As Steve and Sean had mentioned earlier in the process, you're going to be able to make it so resolutions can be made sooner. And you know, before you start developing a map, because I know developers like to do that, like got the whole thing planned out before you even start engaging sometimes with the city planner or the tribe at that point. So early and often bring into the discussions because you may need to avoid a certain area. And then you don't have to go through all of the expense with your architects, your soils people, all of that. That's why it's always really good to hear from the tribe early on, as far as before you start really putting pen to paper even. And like Steve had shared, a lot's happening at the desk. People are coming in asking questions. So if the staff is trained, it's always a good idea, especially if a lot of cities or counties develop, or lead agencies, excuse me, develop standard mitigation measures. And so they know, oh, you need to work with this tribe. There's going to be a pre-excavation agreement, or, you know, before you go out there, you should really have the tribe walk with you on the site. So it's all those discussions so that the planning is learning what the tribe is looking for, just as Steve described with the cannabis locations. All of a sudden you're like, oh, wait, this is probably going to be an important area. The last thing I want to say there is there's always caution about having a developer be in direct communication sometimes with the tribe as far as what information the tribe will want to share with the developer, or even a private landowner, if the developer isn't the landowner yet. There's always concerns regarding confidentiality of information or possible destruction of sites. So sometimes the tribes would prefer to work directly with the city planner or the agency planner so that they know that those sites will be protected. And whether that's through a confidentiality agreement or that's under the, you know, the codes within the state for protection of specific sites, there's sometimes a little bit more comfort in that because there's always a hesitancy. If I'm telling you exactly where the important site is that's going to impact your project, you may want to destroy that. So I just say caution. And that is why I would suggest that always have that intermediary, especially if there is a confidentiality understanding as far as where those potential sites might be.
Mm-hmm. Thank you so much. Just building on the early notification, there was a question about any good faith requirements to continue to reach out to tribes if there is no response. And Steve gave us an example of best practices in Humboldt County. I was just wondering, Mary, does that feed into any of the litigation that the Attorney General is involved in?
Regarding early notification?
If you do not receive a response from the tribe, are you continuing to reach out to the right person?
So there's always those best practices, right? To be able to show that good faith that, oh, we did attempt to contact you. It kind of, you have to rely on that common sense. So Steve's taken that responsibility of making sure he knows who all the tribes are and who their designees are. We are looking at notices and what are the strict requirements and can it be put into multiples? And that is something that, you know, the courts are looking at as well. So in our last amicus brief in the Coin Nation matter, we actually asked the court to not put on extra barriers in developing these responses to notices. The tribe is, you need to always be conscious as like a lead agency or a city, county, is that the tribes typically, this is a typical response, just like Sean, I can't speak for all tribes, but they are receiving hundreds of notices sometimes a day. That's from their federal partners, the local partners, the state partners, the private entities, the CRM firms, everybody wanting the tribe to share about their information. And you really have to prioritize which ones am I going to be able to respond to. So when you're dealing with these complex laws with very specific timelines, it can become very overwhelming. So my advice on that is, if you know the tribe is normally engaging with you, please keep follow up. It could be a situation where the TIPO's on maternity leave, or it could be a situation where they had leadership changes. How many times has there been turnover at your own agency? So it's always good to pick up a phone and call, and not just rely on email or hard letters. Hard mail, what do we call that? Snail mail? US mail. Because some people might not go in the office anymore. But, and that's just developing the relationship. That's just good, solid business practice. Understand who you're working with and pick up the phone, because you don't know that Sean just got a major last minute request regarding a lithium mine, and which will, potentially destroy entire landscape. So Sean's focusing on that. So if you really need something, or if you want to find out if the tribe would like to be consulted with, pick up the phone, in addition to emailing and snail mail. I don't know if that answers your question.
In other words, I understand that since the law does not require multiple efforts at reaching out and finding the right person in the tribe, that may or may not relate to whether the agency has made a good faith effort to engage in consultation.
Well, typically the tribe's notice under AB 52 has the contact information. So if the tribe is changing that contact information, it's a good idea to update your agencies too, as to who they should be contacting. It's a two-way street for sure. But like Steve had said in the beginning, and I love it, he said this AB 52, the laws that are put forth under it are the floor, not the ceiling. So there's a lot of room in there to insert your own common sense and insert something that will be more beneficial. Like the whole list that Steve shared that Humboldt's doing regarding compensation to tribes, and then passing that along in the application process. That's also not included in the statute, but it makes sense because everyone in the room is being compensated for their information, compensated for their time, except for the tribe. And the tribe is providing this information. And, there may be some intellectual property there too. And so it's not always in the best interest of the tribe to share all of their information, because that is theirs to protect and preserve. So it really depends on that trust relationship with the government agency.
Related to that, we had a couple of questions on confidentiality. One is, are there provisions in the California law to protect confidentiality even in the face of public records requests? There are limited exemptions from those requests, but there are issues with public meetings, and the SB 18 guidelines provide best practices as far as how to create a meeting that is not going to trigger public records requests. And Mary, you might be able to add to that. Others may have other ideas of this. And related to this, just more generally, wonder if anyone else has anything to add on how to ensure confidentiality for the information that is being provided.
Actually, can I speak to that quickly?
Of course.
So there's a disconnect here, and I just wanted to address that. Anybody who's worked with me in consultation or met with me in person understands that one of the things that I state is that there are several laws that are written to, according to who's writing the law, to presumably protect First Nations, Native American people and their interest. Few, if any, of those laws are actually written by natives with our perspective and our concern. So when it comes to the law showing up, and you have a person should look at our history and interaction with government agencies and state agencies and the trust, is that the law, when you actually try to apply it at one level, may or may not work. At the other level in the field, in my experience, many times that it does not work. In the sense of when Department of California Transportation developed they're building a 12-mile bypass in Eastern California. Once the site started to begin to develop, I was involved in protecting many grave sites. We ended up having tribal security called to that site to protect areas after we had discovered ancestral remains and funerary objects. That site had been looted. And to what Mary was saying before, pot hunting is people who come out and still look for graves and our ancestral markers or any of our ancestral cultural resources out there. And there's really no way to protect what we experience on a daily basis. Regarding that highway, we ended up protecting over 100 graves, but the ultimate solution became working with engineers to develop how to build a highway 10 feet at a time. There's many stories around that development. I'm not going to get embroiled in it, but the reality of it is that non-disclosure agreements with, for instance, maybe even state directors or governors, or governor or state director, or the person who's actually in charge, a commissioner, may be the only way to sharing confidential information and holding those leaders accountable. And so if development is that important, then that's the kind of engagement that I believe, in my experience, and if I was a tribal chair, that's what I would be asking for, is if this project is so important that we have to disclose what our cultural sites are or how we're going to protect them, then we need agreement at the highest levels. And that would, in my mind, go to government consultation, where you have the leaders trusting leaders. At my experience as a TIPO, being under my tribal leadership, I consult on cultural concerns, but it's not my place to even make those types of agreements. All I can do is work towards suggestions and solutions. Again, I yield the floor to other perspectives.
I guess I'll just say I have a project at the Planning Commission tonight, and when we circulated the mitigated negative declaration for it, we did not include the cultural resources survey as part of what gets uploaded to the Sequenet. It's referenced in the package, but it's not included, and it wasn't appropriate to include. It also isn't included in the public documents that are provided to the Planning Commission in advance of tonight's meeting. So there are other ways to approach that. CRM professionals can create a kind of dumbed down version of the report that doesn't divulge sensitive information, but really that should only be done through the TIPO, and with the understanding that the report is ready for public consumption. So in light of that, I am always leery of including that information in any public facing parts of a project.
Just to add to that, because these are public proceedings, and as Greta mentioned, the Public Records Act here in California, there are specific protections put in place, and those you usually put in our government code. So for burial areas, sacred places, ceremonial sites, those are specifically protected in Government Code Section 6254, subsection R, I believe. So all those lawyers out there, please forgive me if I mistake, if I said that one wrong, but it's 6254 subsection R. And that is to protect, again, these are the state of California has recognized that these are places that need to be protected. And so it is specifically excluded from the Public Records Act. And then to both of your points regarding the actual environmental documents, those appendices are usually kept confidential. If a tribe does discover that all of a sudden your maps are being shared or whatnot, The Office of Historic Preservation is also an excellent resource. They are able to reach in and let the agency know that they are providing confidential information that needs to be excluded from the public record. And then if the agency continues to violate that, they could actually lose their ability to have access to those types of maps and informations. And that is something that no lead agency wants to do, because then you can't do your job. So again, it's an understanding between the agencies, the tribes, that this type of information really does need to be kept confidential. I know there are others that look into non-disclosure agreements, looking at, I'm not providing you a map, you should just talk to me about it and I'll show you, but you are not to recreate it. Those are all part of the relationship building and how you want to exchange information with one another. I know there's sometimes fears, and well-founded given the experience of most tribes in California when dealing with locals or state agencies or sometimes federal agencies, that if I share my information with you about where these sites are located, you are now going to disregard involving me in the future because you just took all my information, and now I am not relevant to your discussion. So it is important that there is those base understandings as to how you're going to share information and what the expectation is for both sides on how the information is to be used and if it can be shared. I liked hearing what Steve shared about Humboldt County, that they have internal review purposes only for certain information that's shared with them by the tribes. And hopefully they even have designated people so that not everybody has access to that information. The Native American Heritage Commission has a sacred lands file. That's a similar process where they receive information from the tribes regarding specific sacred areas, that is not accessible by everyone. So it's very important that these processes are developed so that good expectations can be had, and so that that trust can just keep evolving, in my opinion.
Thank you, Mary. There's so many good questions. We won't get to all of them, but I want to pick up one on a little different tact. We have a question: what is the lead agency's responsibility when there's more than one tribe in consultation and the tribes are not in agreement? Does anybody have any suggestions there?
I'd like to go quickly on that one, and then yield the floor. So that's exactly the idea of consultation, is that sometimes you can get tribes together regarding even cultural concerns. As TIPOs, we work, the tribes in our valley work together to address cultural concerns, which sometimes there's great consensus, and usually we don't have a difference of opinion. However, each tribe has their own history and interaction with agencies. Some of them have their own needs, and that's the right and privilege of each tribe to call for separate consultation and meetings, because sometimes the tribal leadership will have disagreement or have different concerns that they have. And you also have to remember that tribal leaders, and this is something that a lot of people don't understand, is how we govern. So the general council with elders may have different concerns as well. And when it comes down to that, just for the agency, sometimes they'll be working in an area that has 8 tribes, and they may not like that. Sometimes they can get them all together. And if they can't, then they may be in a position where they're going to have to go and consult with each of the 8 tribes. In some areas, it's 17. So look for cooperation where you can. And when there is not cooperation, please don't be frustrated with the idea that that you're going to have to consult with each of the tribal leadership, whether sometimes even whether appear before the councils, which leads to capacity problems. And if we only meet once a month for our tribe, so some people want to put us on a 30-60 day limitation. If I don't get to my general council for 2 months, I may not have an answer for 3.
Any other thoughts on dealing with diverse views from tribes on a particular issue?
Just to echo what Sean said, you have to work with each tribe independently. It is convenient when the tribes are of a similar mind, but that's not, you can't expect that. And you have to allow for each tribe to be given their opportunity to participate and represent their interests and position on a project. So it can be challenging, and that's just how we got to negotiate. So get through it.
Yeah, I would just echo that. The tribes, you can have multiple tribes that are traditionally and culturally affiliated with one particular area. There's a lot of shared territories within the state, and it's important that the lead agencies, one, come to a table understanding that, but two, being able to hear everyone regarding their concerns about the impacts to those potential tribal cultural resources. Hopefully there can be consensus building when you're hearing from multiple tribes about protecting the resource, and hopefully from there you can develop some appropriate mitigation measures that would be appreciated by both different cultural discussions.
Final question, which is a little general, I guess, is a couple people asked about informed consent, and one says, if a tribe says no, what are the next steps? What happens if the no is not respected? My sense is that improving consultation and relationships is one step. Certainly, the consultation laws do not require that there is informed consent. Does anyone else have any other ideas on that one?
Well, as a TIPO, when we don't, I'm beginning new types of thoughts on that moving forward. And so then that's what part of what mitigation is about. And part of the gray area becomes is when we ask for mitigation as tribes, we don't want to come across as this is payment for destruction of our lands or permission to destroy, but to compensate. Because these are ancestral lands, but they're on Bureau of Land Management, California State Lands Commission, or other agency lands, private ownership, we can only go so far as saying no. And this is part of beyond consultation and probably even beyond law is or into law. How do we get into lawsuits or settling and disputing who's right? Just as tribes can say, define what a cultural resource, tribal cultural resource is, we also don't, other people don't have to agree to that. So they become very complex situations when we get to that. We try to always get ahead of lawsuits or those areas. And so one of the bigger projects that I worked in was I was being told at lower levels that the conversations we were having were government to government. And we kept pushing back as tribes saying, no, this is not. It's when you get to the state director and that state director is talking directly to the tribal chairs. That's when actual government to government consultation happens. And I'm very careful to describe in meetings that I have that I'm only representing my tribe as cultural concerns and trying to understand what's going on. Sometimes I can reply back to responses, environmental assessments, but many times when it comes to that level, that's where that consultation needs to escalate to who's in charge of the project, but actually to the agencies, directors, commissioners, and those levels. And that's where sometimes the conversations directly need to go. Thank you.
Thanks very much. I want to thank our wonderful speakers, our audience for attending this webinar. And I did want to let you know that the results of the study will all be posted on the Tribal Consultation Hub. Provided a QR code for that earlier, and it's available at tribalconsultation@eli.org. Thank you very much.
Thank you so much to all of our fantastic speakers for joining us today. Thank you to Greta for moderating, as well as to Sean, Steve, and Mary for their wonderful presentations and insights. We so appreciate all of your time and energy to make this program happen. Thank you as well to our audience for your engagement and for asking so many great questions. We had a lot of questions and we apologize that we couldn't get to all of them, but thank you for your time. If you missed any part of today's webinar, there will be a recording posted to the ELI website within a few business days, so be sure to check back onto the event webpage for it. If you enjoyed today's webinar, we encourage you to check out ELI membership to gain full access to all of our educational programming. You can find out all the information about that at eli.org. With that, I'll bring today's webinar to a close. Thank you again to everyone, and we hope you have a wonderful day.